Casey, you want to talk?
Yes. How's it going?
Trying to be efficient.
I have Allison Dennis today. This was one where I had submitted a PTI appeal back at the beginning of March. You asked me to follow up on it. I
Anything?
did. I got an out of office email from Ashley Geis. So
How long is Judge Geis gone, do you know?
I believe she is back today, Your Honor.
Is it a week?
okay.
Yeah.
Can we wait for appearance again?
Yeah,
Okay.
if it's granted or denied, she's got to be here. Have you done the TRAS yet? No?
No, we've been waiting
So
to
that's why-
see. I mean, I can schedule one and then cancel it. Okay.
Just do a walkthrough next week if she's
Okay.
granted. Just bring her here, we'll do it. If she's denied, also come here, we can take care of it.
Okay.
Okay? If it's no answer, then we'll wait.
Okay. Perfect. Thank you, Judge.
Joe?
Judge, I'm gonna let, Jose kind of had him. Hi, Judge.
Oh, no, I need more time. I got to get a record.
Okay.
So Ramona, can you get ready, please?
Yes, Judge. Oh, well, I can come out in the courtroom.
It's up to you, however you want to do it.
Okay.
Okay, you ready? All right. Good morning, Mr. Arroyo. How's jail? Fun?
Oh, sorry.
So February, you have a terroristic threat with us of a family or household member, and now you've picked up an evading arrest in a motor vehicle. While you're on bond for this case, you pick up a serious third-degree felony. What happened in the terroristic threat?
There's a threat, Your Honor.
The terroristic threat in our case, please.
In our case, on February 3rd, 2025, an officer responded to a weapons disturbance at a residence in Harris County, Texas. The officer met with the witness who stated that her granddaughter's boyfriend, the defendant, was upstairs in the house with a gun. The witness stated there were 5 other people in the residence and everyone exited the residence safely except for the defendant. Officer met with the witness who stated she had been dating the defendant for 3 years and broken up with him hours before, and the defendant left the residence. When it was asked the defendant if he wanted to retrieve some items, and the defendant said no. The defendant came back to the residence and the complaining witness refused to let him in. Short time later, the defendant sent the complaining witness a picture of him inside her vehicle pointing a handgun at her bedroom window. The complaining witness saw a laser through her bedroom window, which she knew was attached to a handgun that he owned. The defendant threatened to kick her door down and make forced entry into her home. The complaining witness still refused, and the defendant began hitting the windows around the house and screaming the complaining witness's name. The complaining witness called 911 and went inside a different bedroom.
Like something out of a movie, like a horror movie.
A second witness, the uncle, led the defendant inside the residence because he was unaware of the break-in. The defendant went straight into his room. The officers tried to make contact with the defendant but were unsuccessful. The defendant was identified by a photo and date of birth.
So tell me what happened now in the new, please, in the evading.
Yes, Your Honor. On April 2nd, 2025, a law enforcement officer was dispatched to a vehicle in reference to a discharge of a firearm. While searching the neighborhood, the law enforcement officer made contact with the witness who advised that the driver was a Hispanic male with light bushy hair, and the vehicle had a plastic wrapping around the rear window with one laminated tail lamp. The law enforcement officer continued to search the neighborhood and observed a vehicle that matched the description. The law enforcement officer made a U-turn and pursued the vehicle. As the law enforcement officer approached the vehicle, the driver accelerated speed and disregarded a stop sign.
Tell me they found a gun.
The law enforcement officer do not have that, Your Honor. The law enforcement officer initiated lights and sirens to stop the vehicle, failed to stop, failed to stop, accelerated speed and disregarded multiple stop signs for approximately 3 minutes and around 1.5 miles of roadway, reaching a speed of 62 miles an hour. There were multiple areas the defendant could safely stop, and the defendant stated he evaded because he believes he had an open warrant for family violence. I
Is this
believe
in warrant status? Do we know?
this wasn't warrant status, Your Honor. Let me.
It was a 2B, Your Honor. It wasn't. It was a 2B that was filed. It wasn't a. So I think they're speaking about the terroristic threat, family violence in our case, and it was filed as a 2B. He never was arrested on it or didn't have a court record.
You know, Mr. Arroyo, you need to think that in this world, when you go to jail, you now know you have no one that's going to pony up money to get you out. So when you go to jail on charges, you are stuck unless someone's, right? Since January, you've had an unlawful restraint, an assault of a family member. Now you have these two open cases. Why would we continue to give PR bonds?
If I may, Your Honor, the two previous cases, the unlawful restraint and the assault family member, the file date was back in 2023. He had it set for a jury trial and it was dismissed. He never bond forfeited.
You represent him on this case?
I did not. I was just appointed today to
Okay.
him. But I'm just looking at the procedural posture of the case. He does not appear to be a flight risk of any kind. He took those cases and
Well, I mean, he's evading capture now with the police, you know? Something's going on with you, man. I don't know what's going on, but who do you have in your life? Who's around to give, our mom, dad, who do you have? You got a son? What? You're a baby yourself. How the hell? I mean, do you live with mom?
I live with my mom.
Well, that's what I'm asking. Who do you live with?
Yeah, I live with my mom.
Do you actually live there or are you out on the street all the time?
No, I actually do live there. I stay there and I take my sisters to school in the morning and pick them up after school. And I work and I take care of my son every day that I can when I'm not working. And he sleeps over if I'm not going to work the next day. That's all I'm really doing. But
In the
I
last
just-
couple months, you've had 4 charges. What do we need to do to ensure you don't pick up a 5th?
he is now living with his mother. It sounds like before he was staying with the complainant. So the change in location is going to be helpful, certainly. He now has employment. He works at Cosmic Air.
Let's do this. If you can, is mom here? No.
I don't believe
No,
so.
sir.
So let's do this. If you can verify that she will actually take him, because I'm not giving you a PR bond or even a bond reduction for you to just go out on the street.
Sir.
If I let you out, I'm putting you under very strict rules. No dope, no alcohol, and I'm going to test you like crazy. Does he have a license? You're not allowed to drive. I don't care what you got to do. I don't care about your little brother having to go somewhere or your son. If you don't have a license and you don't have car insurance, then no driving. That is a bond condition. I'm going to have you sign an affidavit promising you. If I find that you do, I can have a contempt hearing an additional 6 months.
Sure.
But I'm not letting you out unless you have a stable place to go to, because I don't want you out on the street. Nothing good. And I'm giving you a curfew as well. You understand?
Sir.
I'm going to put a monitor so I know where you are at all times and then we'll talk. But first things first, not to the street. If you can verify that he's got a place, then let's talk. And I'm happy to do something.
Thank you.
Yes, ma'am. Yes. Okay. Joe,
You're present.
that way. Guys,
Thank you, Judge.
hi. Yes, ma'am. Good morning.
I have Mr. Arroyo on your in-custody docket.
Okay.
We're here for a bail order.
And for what it's worth, you don't really have to approach. The only time is if you need something, then just for, it's a high bond, huh?
It is, Your Honor. We are requesting the PR bond.
Say it again.
We are requesting the PR bond, so.
In that case, I'm gonna,
I'm so sorry.
I'm gonna need, do you need an interpreter? Sean. You need an interpreter?
Yes, sir.
Sean, talk to me while we're waiting. While we're waiting, talk to me.
This is Mr. Arroyo.
Okay.
In custody. I was able to speak to his mother. She gave me the address. They've lived at that particular location for 10 years. She verified that he does live with her. And he can continue to live with her. I advised her what the court said about taking the siblings to school, and she said that's not a problem. She'd be able to handle that.
Okay, great.
And so I wanted to reapproach that.
I will. I'm gonna put a monitor on him.
Sure.
Okay, GPS monitor, so we don't lose him. Okay, no drugs, no alcohol,
Yes.
testing.
Yes. And the GPS is an exclusion zone or a curfew?
Curfew, so he's not out in the middle of the night.
There's a current 7 to 7 curfew.
Yeah, that's too much, but like 9 to 6. Yeah. And let him know that, it's okay, go ahead.
No, I was just gonna ask the state, but also like to ask for an excluding zone if possible on that.
Oh, that's right, not going back to, yeah, you're right, no weapons, then no, you're right. So the exclusion zone is no going to the complaining witness, no, not to go within 500 feet of where she lives, works, no contact with the complaining witness, and please admonish him that he's not gonna get another one.
About him making it to
This
court.
courtroom session starts with a serious warning from Judge Fleischer. Mr. Frederick is already under bond conditions, and the court is now dealing with an alleged GPS exclusion zone violation. The judge makes one thing very clear. Bond conditions are not suggestions, and violating them can lead directly to jail and the loss of PR bond privileges. Frederick also says he cannot afford an attorney, so the court begins a process of determining whether he qualifies for appointed counsel. But this is only the beginning of a much larger courtroom session involving driving restrictions, family violence allegations, racing, bond violations, and defendants facing increasingly strict conditions. The judge repeatedly emphasizes community safety and compliance with court orders. As these cases unfold, the key question becomes simple. How much patience will the court have when defendants are accused of ignoring conditions that were already placed on them?
Him making it to court.
Okay. I had his
When's-
bond at 5,000 two FTAs ago.
Judge, may I approach? I'm so sorry. Hi.
Wow.
Hi. Are you talking about Mr. De Leon?
Yeah.
I'm
Yes,
here on that.
Are you hiring on?
No. I'm the prosecutor.
she's
Judge.
with the state. Yeah.
Wait, what?
What? Wait a minute, you forgot. Yes, I'm with the state. I am now the only environmental law prosecutor.
Wow.
So, hi,
Well,
nice to
welcome
meet
back.
you.
Because I,
Could you agree to a $5,000 bond, please, ma'am?
Are-
Would you agree to that?
he's asking if you would
Yes,
agree to it.
that's fine.
1,000.
I'm gonna give him one more chance to complete his cleaning green, and if he doesn't, we'll just do conviction alternative.
Well, but
I know.
4 different times?
Yeah, I'm just gonna give him one.
I'm not
last-
letting him out. I'm not giving a PR bond.
No.
I'm gonna agree to the 5,000.
Okay.
And ma'am, if you could make an offer, we appreciate the PTI. I've reviewed that with him. If you could make a time offer for Wednesday so we can go over some options, please.
I'm sorry.
No, I want to do it.
You want me to clean?
Mhm.
You can lead a horse to water.
Well, then let him sit.
Well, that's what he's saying. Because I mean.
Wednesday, if you make an
my
offer, I
name
can
is
discuss it with
Benny,
him.
Can I see who am I talking
He's,
to?
why is he's not, it's James Pons.
Oh, can I go talk to him? No, I'm
James,
asking him.
can you chat me your phone number? Do you mind?
No, I meant Mr. De Leon. Can I go talk to him?
Oh, well, I don't know. Can she go talk to your client? James?
Okay. Can she call me first? I'll shoot you my phone number.
All right.
Hi.
Thank you, Judge.
Yes, ma'am.
Morning.
Good morning.
I have an arraignment
Okay.
on Mr. Fatucci. It's BYTY. Okay.
Okay. Do you mind bringing him up? Do you need a translator? No? Good morning, Mr. Shea.
Good morning.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, I'm sorry, I didn't stay.
SHA.
Judge. On March 30th, 2025, Williams County, Texas, an officer was dispatched to a family disturbance call. The officer met with the complaining witness who stated that the defendant is her husband. The complaining witness stated that the defendant and her son, who has mental health issues, got into an argument where the defendant slapped her son in the face. The complaining witness then intervened by getting between them. The defendant then grabbed her by her hair and pulled it, causing pain. and then left to the garage saying that their children would grow up without parents.
Judge, if I may, they did a rip call, and in the rip call, it indicated that she didn't feel any pain.
Judge, let me clarify, but the recall says specifically is that you got in between them and you grabbed her hair a little bit. But it was reiterated, that this hasn't happened before, and that she was not hurt. Does not say she didn't feel pain, just that she was not hurt.
Did the officers ask whether she felt pain at the time?
The judge says that the complaining witness stated that the defendant grabbed a hold of the complainant's hair and pulled it hard, causing her to feel pain. That's as the injury.
It does say that.
It does say that the injuries grabbed a hold and pulled it hard.
Mr. Shape, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know whether she wants to have contact with him? A protective order has been issued in this case. You need to get to know it. If you do something to violate this protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up.
The complaining witness is asking to drop charges and to drop whatever bond conditions exist, Your Honor. I don't know if that's.
So what I'm going to do is I'm going to order you not to have any threatening or harassing contact with this person. If I find that you do, I will revoke your bond and put you in jail. You need to understand that what is threatening or harassing doesn't matter what you think. I could care less what you think. It's what she perceives. Do you understand?
Yes, Your Honor.
And you've got a lawyer. The lawyers will take care of you. I will waive your appearance so you don't have to waste your time coming to court, but stay in touch with them. They'll tell you if and when you have to come back to court.
Thank you, Your Honor.
Do you mind filing no threatening or harassing conduct?
Yes, Your Honor.
And we can amend the MOA for you as well to take off the residential restriction.
Thank you, Judge.
All right, sir. So what I'll have you do is we'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We're going to get bond conditions created for you. Once you sign them, after that, you'll be free to go. Do not leave until you sign the bond conditions though, sir.
Thank you.
Okay, thank you.
Thank you, Judge.
Mr. Frederick, I'm going to find that there's sufficient probable cause to go forward with the case. There are bond conditions that the magistrate placed on you. If you fail to live up to those conditions, if you violate those conditions, a warrant for your arrest will be issued. You will go to jail. No more PR bonds for you. Do you understand? I'm going to do everything in my power to protect my community at all costs. I don't care who you are, what color you are. You're a small farm animal. If I find that you violate these conditions, I don't care what your excuse is, you will go to jail. So, Felicia, tell me, what conditions is he alleged to have violated?
It's the GPS exclusion zone. He has a GPS device with a curfew as well as an exclusion zone for the 12,000 Martin Luther King Boulevard address.
Okay,
However, it also seems to be the residence of Richard Collins.
okay. Have you guys done a rip on this case? Do you know?
I believe we've attempted one, Your Honor, but we've not made contact yet. Or I'm sorry, I apologize. We have made contact now, Your Honor.
What does she want? Does she want to have contact with him? Does she not want him to go back? Mr. Frederick, do you have the ability to hire a lawyer?
No, I don't.
Okay, I'm gonna need you to fill out an application for me. I need to know whether you qualify. We don't just give out court-appointed lawyers like it's candy. You have to qualify for it. So what we'll do is Deputy Miranda's gonna give you an application. I need you to fill it out. I need to know everything about you, what money you have in the bank, what kind of money you make, what kind of job, cars. Let me take a look at it. I'll see whether you qualify. Do you currently have a monitor on you now?
Yes, I am.
You are not allowed to go back to this house. I don't know whether she wants to have contact with you until I know. I'm gonna honor these bond conditions. Do you understand?
Yes.
Okay, so let's first see if you qualify for a lawyer. If you do, I'll give you a lawyer and then we can go further. Deputy Miranda is gonna give him the application. I'll have you sign a reset and then we'll have you take a seat in the jury box. Hi.
One, I don't think I've ever seen you that in a bow tie.
Yeah, it's few and far in between. What,
So this is, I talked to our conviction and integrity unit, who's sending out the letters and the notices to the individuals that have the wrongful conviction.
Right.
And what we're doing is, of course, the ones that are inside 30 days, and we can just come to court and fix them. When they're outside 30 days, what's happening is they're either hiring a lawyer to file a writ that's unopposed,
Okay.
or they're being appointed a lawyer.
I'm happy to appoint all of them because it's our mistake, so there's no reason for them to have to use money.
All right, and they're going to be unopposed.
Okay.
So it should move very quickly. I know it adds a case on the docket, but they're.
I don't care. It doesn't matter, really. It's nonsensical to get up in arms. So the idea is that we streamline it so that we know we have it,
Yes,
deal with
sir.
it fast, so they don't have to take a lot out of their time
Yes,
to
sir.
deal with it. So I guess what I'll do is I'll start letting you know when we have one come in. Is that all right?
That would be great.
Okay.
And then we could do it, like I said, we could do it unopposed. There's no, as far as I'm concerned, of course, it's up to you, but we don't even need them to appear in court. We can just do.
Okay.
Just get it done.
The one we have on here on Friday has a bunch of open cases now. So are we still going to
This is
do
where
it
the
the same way?
courtroom tension really escalates. The defense is arguing that the defendant believed he was legally allowed to drive because his license was valid, and he had allegedly received information from pretrial services. But the judge focuses on something different: the existence of a court order. The judge explains that even if someone believes they have permission to drive, they cannot simply ignore a restriction and ask for forgiveness afterward. That distinction matters because the court is not only looking at what the defendant believed, the judge is enforcing conditions that were actually ordered. The defense also points to information suggesting there was never an active license suspension, creating a direct conflict over what the defendant was legally permitted to do. So what matters more here? Conflicting information from pretrial services or the court order itself? The judge's response makes his position unmistakable as the hearing continues.
Are we still going to do it the same way?
Do it the same way, unopposed, and just move the case.
Okay.
Thank you, Judge.
We're waiting on him to file a motion for new trial. Once he does, then I'll send you notice.
Thank you.
Okay, great.
Thank you, Victoria.
Okay, thank you so much.
Yes, sir. May I be excused, sir?
Whoa, thanks for coming.
Thank you.
Page 11. Fernandez.
Yo soy su intérprete. Me parece que conteste todo a voz alta.
Okay.
You are Ernesto Hernandez.
Andes.
Yes.
Mr. Hernandez, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Bien, será
You
usado.
have the right to have an attorney represent you. If you cannot afford one, one will be appointed to you, sir. Okay.
Judge,
Nada, escuche.
on March 31st, 2025, in Harris County, Texas, law enforcement officer was flagged down by the complaining witness who stated that a vehicle was driving the wrong way down a one-way street and damaged the complaining witness's vehicle and did not attempt to stop. The complaining witness stated he followed the defendant to a dead end and called the police, then found the law enforcement officer. The complaining witness then showed the law enforcement officer where the defendant's vehicle was parked. The law enforcement officer found the defendant asleep behind the wheel of his vehicle. The complaining witness was able to identify the defendant as the individual who was driving the vehicle at the time the damage occurred. The complaining witness estimated the damage to be $800 to $1,000.
Estimaron que el daño, I'm sorry, the amount
$800 to $1,000.
entre 800 a $1,000.
So he hit the vehicle and
Así
took,
que él le pegó al
Yes,
vehículo
hear that you, and how far did he go?
y que tanto
I'm not
siguió.
sure.
Dice, no estoy seguro.
It occurred near
Eso ocurrió cerca de
340 South 69th Street.
342 Sur,
And then there
calle
was a dead
69,
end
entonces
at
es una calle sin salida,
that the defendant was parked at
donde
300
estaba
South
estacionado el
7th
acusado,
Street.
cerca de la calle 70.
Read the part where the accident,
Dice,
please, if you don't
lea la
mind,
parte
into where he took
cuando
off.
ocurrió el
Yes,
accidente
Your
hasta
Honor.
dónde.
I didn't hear it.
The complainant stated a
El
vehicle was
denunciante
driving
dijo
on
que
the
un
wrong way
vehículo
on
iba
a
en otro
public roadway
sentido en una carretera
as a one-way
pública,
street.
que era una calle de un sentido.
And the complainant stated the defendant
Dijo que el
damaged
acusador
his
dañó
vehicle
su
when the
vehículo
defendant was driving the wrong
cuando
way and did
estaba,
not attempt to stop.
cuando estaba manejando
As
en
the
una vía en
defendant
contraria. Entonces no paró de información.
And then he goes to a dead-end street
Es una calle sin salida.
Yes, Your Honor.
Sí, sí.
and falls asleep.
Yes, Your Honor.
Do we know if alcohol is a factor?
Ha consumido
It's not
alcohol.
alleged, Your Honor.
No se alega eso, su señoría.
I'm not sure that there was any
No estoy
investigation.
seguro si hubo una
Yeah,
investigación.
Mr. Hernandez,
Señor
I'm
Hernández,
wondering if there's
voy a
sufficient
encontrar la
probable cause to go
suficiente
forward.
causa para seguir hacia adelante con su caso.
On his license, please.
Yes, Your Honor.
If you do not have a Texas driver license and liability insurance in your name, you are not allowed to
No se le
drive.
permite manejar.
Do you
¿Lo
understand?
entiende?
If I find that you do,
Usted
I will put you in jail.
vamos a meter a la cárcel.
His license is eligible.
I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you,
No
they
encuentra
can possibly put a detainer on you and you will be stuck like Chuck in there
como yo.
until this case is over with. Do you understand?
¿Lo entiende?
It
Yes.
is a bond condition that you're not allowed to drive unless you have liability insurance as well. Do you have the ability to hire a lawyer?
Has de contratar un abogado.
Sí contraté uno.
Yes, I hired one,
No, no ha llegado, yo creo, no sé.
but he hasn't gotten here. I don't think so. I don't know.
Oh, Judge, he had,
I
they
don't
called
see
this morning and they said that the attorney had to go to a different court, but he was going to be on his way. And
Did
they
they
thought they were
identify
following up.
who,
La oficina.
see anything filed
Yes,
there?
yes.
Oh, you do? Who is it? 'Cause I don't see it. That's
It is Mr. Pass.
David Potts. Okay. So what we'll do now, Mr. Hernandez, is I'm going to have you sign a receipt, Victoria. We will have you take a seat in the jury box while we get your bond conditions. We will also wait until your lawyer arrives.
Su abogado.
Please, do you mind filing no driving without both?
Yes, Your Honor.
Hi. Yes, ma'am. Good morning, Mr. Reyes.
Morning.
Sir, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, a law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of South Highway 6, turning left. The law enforcement officer at a highway, I'm sorry, turning left at a highway speed. The law enforcement officer made a U-turn at the intersection to follow both motor vehicles having to travel approximately 66 miles an hour in a 40-mile-an-hour zone. Law enforcement officer observed the motor vehicles to be side by side with the Honda flashing emergency lights. Law enforcement officers observed the Honda turn off its lights and both motor vehicles began to speed up again while driving side by side and run a red light. Law enforcement officer attempted to catch up to both motor vehicles, causing the law enforcement officer to travel approximately 90 miles an hour in a 40-mile-an-hour zone. The law enforcement officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. A traffic stop was initiated and the law enforcement officer made contact with the driver. The defendant stated, when asked about the highway speed, no, I was on my way home with my friend Adam, and Adam was following me home. Co-defendant arrived claiming he was there to check on the welfare of the defendant. Co-defendant stated I was flying home, but I broke off because I wanted to get something.
So we do have a co-defendant?
I believe.
You know?
One more check.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? He has a license.
Yes, Your Honor. And we do have the credit in this. Got it.
I'm ordering you as a condition of your bond not to participate in this type of activity anymore. You're not to race, do any street takeovers, donuts, driving maniacally. If I find that you do, I will take your privilege to drive away from you, and then I'm going to put you in jail. Do you understand?
Sir.
I'm not asking much from you. I just want my streets to be safe.
It's eligible, Your Honor.
Okay, you're also not allowed to drive unless you have liability insurance in your name. All those are conditions of your bond. You violate that, it's not going to go well for you. You understand?
Sir.
Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Roth, and he'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you because you're playing games, likewise, I will revoke your bond. We'll have you sign a receipt with Victoria. We'll have you take a seat while we get your bond conditions. You'll sign it, and then you'll be free to go, sir. Thanks. Thanks. Take care.
This one was PHA. We already filed PC.
Oh, we did?
Just
Okay.
had to hire an attorney.
Got it. Okay. So if we have the bond conditions already in there, then free to go. Okay, all right, thanks. Please. Okay, Mr. Johnson.
Just good morning. I've got a bond violation on Joe House.
Yes, give me 1 second. Mr. Lester, he's been waiting.
Yes, sir. Good morning.
Hey, who's your client, sir?
My client is Nestor Daniel, I can't pronounce that name, Carrillo, Carrillo. Would you like a case number?
Sure. Let me make easier. What is it?
Case number is 25-52-19-00-1010.
It's Zeniauskas.
That sounds good to me.
Okay. Do you have proof that he's in ICE?
I can furnish the court proof. I'll provide the court with a denial of his bond. We had the hearing. He was denied. His case has been set, the merits hearing, for May the 6th.
Does that mean that you're trying to get him another hearing for a bond?
Well,
I don't know how it goes over there, so I have no idea.
well, his bond was denied because the court did not have jurisdiction because he was an arriving alien. So he is in the custody of ICE at this point. They are not going to release him. And
do you want us to bench warrant him back here so we can take care of this, or leave him over there for now?
I'm not really sure on the answer to your question, Judge. I
Say it again?
think that would primarily depend upon you. Do you want to get him in front of you?
The
sooner
thing
rather
that I
than
don't
later?
want to happen is I don't want them to end up deporting him without having taken care of this case first, because then it's a headache for everybody involved. You know, if he wants to come back, he's got the open case, he'll have a warrant. It's a huge headache. So page 22. You want me to just bench warrant him here so we can take care of it? Mr. Lester?
That would be fine. That would probably be wiser.
Okay. And I don't know, maybe you can reach out to the higher ups with the DA's office here, whether there's, a diversion is available. I don't know, just reach out to them, and then we'll bench warrant him here, and then I'll give you a heads up when we do get him.
Okay, thank you, Your Honor. Just make sure the court understands that his individual calendar hearing, his merits hearing, is May 6th.
Okay.
Anything further, Your Honor?
Yeah, let me see. Hey, so we're gonna bench warrant, bottom of 22. Do we need to put him on a new date?
Yes, they require at least 2 weeks, so how is the 21st?
How's the 21st of this month? Is that okay with you?
I think that'll work, Your Honor.
Okay. And you still welcome to zoom in if you need to. And if we don't get him, we'll just give you a heads up, and then we'll see where we go from there. Okay?
Very good. And you're giving me a reset to the 21st. Is that correct?
Yes, sir.
Council Foley?
Okay, thank you, Your Honor.
Reset to the 21st. Okay?
Judge, you told him not to drive. The allegation is that he was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
So, okay.
There was never a suspension on his license at all. He's been good to drive.
But he was also drinking.
Well,
The concern was that he was drinking. And
but Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
He was drinking allegedly and the
Yes.
license was suspended.
Yes.
Can you
And-
run his license, please, to the state?
Your Honor, it does show to be eligible to.
Did it just become eligible or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
had to
more
go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do it tomorrow?
I'm already
Let me
here,
look at
Judge.
what,
I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
said, what day was it lifted?
4/2/2025, from what I can see on the license. NCIC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
Does he have an interlock as well?
Yes, Judge, he has interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a layperson who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This is all premise on wrong information that he couldn't drive. He can drive. There's nothing wrong with his license. There was no ALR suspension ever. The state told you that. That's why you.
It was a suspension
It was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal ordinance from jurisdiction? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing you.
ALR suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
Appeal 12/6/2024, end date 6/3/2025, and the lift date comes in at.
And then if that's,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court
I
order.
understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right? I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pretrial, not anyone else. Do you understand?
Sir.
All right. Good luck, sir.
Thank you, Judge.
Good luck with your appointment, Mr.
Thank you, Judge.
Counsel.
Judge, just to be clear, is he permitted to drive now?
As long as he has the interlock, he's got a valid license and he has insurance, yes.
Does the affidavit need to be?
Yeah, we'll rescind it. Don't.
Francisco Ochoa, he is present in court. He just bonded out a felony, or bonded out of jail on a felony this morning, came straight to court.
Okay, you mind bringing him up? Can you run his license, please?
Yes, Your Honor. Eligible, Your Honor.
Okay, all right. So, Mr. Ochoa, the only bond condition I'm placing on you now is don't drive without a license and insurance. So as long as you can abide by those, I'm going to be happy. The only other thing I want to say, you now have two open cases. You pick up a third case, it's really not going to go well for you. You understand?
Yes, sir.
Keep my community safe. Otherwise, I'm going to violate the bond. Do you understand?
Yes, sir.
Okay, they're going to follow conditions. He needs to stay to sign it and then he can go. Do you want the same day as a felony?
Next day, we got it, already put in already.
Perfect. Okay, thanks. Hi. Yes, ma'am.
There
Good
is a
morning.
victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I don't want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So,
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for
Fine,
them
there's
and then
no
we can
rush.
do it?
Judge,
Really?
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
But
just.
that's what I'm saying. I'm letting the court know. I think that's kind of
To
unfair to
see
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Can you
Can we-
stand down for a bit?
I'm sorry?
Can you
Just-
stand down to see if she's available to
She
Zoom?
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No? Can you reach out to her real quick and just see? I know you're in the home stretch, dude. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
Sean. Blaze. Talk to me real-
All right, there you go. You're free to go.
Ramona. Is she out? Jose, do you have the cause number on that?
Here.
What was it, please? Michael, I'll hit you up next.
25.
Chat me who you have, please. Okay, ready?
1
Okay,
8785.
okay. That's right. Guys, we're going on the record. If you need to talk, please go outside. All right, we are on the record in cause number 251-8785. This was a motion to suppress, a dispositive motion to suppress that we had. I'm going to grant your motion. We had reset this case. If I'm not mistaken, we had reset the case several times because of the availability of the officers, right? I mean, just to be nice, right? And then we have this motion to suppress. They get here and it's like, they didn't even look at it. And it was just, it's something I've never really dealt with like that. And so I found, I didn't find any credibility with the testimony, so I'm going to grant your motion.
Right.
So, off the record, I think that this is a great teaching moment where you should never assume officers are prepared. When you first go to them and when you're preparing for trial, you ask them and say, hey, have you read over this? Are you familiar with it? Are you ready? You never assume. I mean, that was just 101. So for what it's worth,
All right. Thank you,
Okay.
Judge.
Yes, Your
It is what it is.
All right.
And then, I'm sorry it took so long.
No, it's okay.
So
Judge.
just get your client, I don't know if your client has anything like any interlocks
He has an
or,
interlock.
so just have him come back and
All right.
then we can take everything off.
Okay.
You know, once we enter in the order and it shows dismiss, he'll be able to go to, I think, pre-trial and they'll be able to take it off.
All right. Thank you, Your Honor. May I be excused? See you, John.
Okay, Michael.
Morning, Judge.
So Juarez, huh?
Yes, Your Honor.
It's a good Monday. James Pons.
Morning. I had Mr. DeLeon in custody. I had two requests. One, if you would help out with his bond it's at 10,000. I know he's missed court. I've had a discussion with him. If you can make it 5,000, please. And then my second request was to put the case on Wednesday, so we can dispose of it appropriately.
Okay. So we can put it on for Wednesday for you.
Thank
And
you.
want a bond reduction?
Yes, it's at 10,000 right now on a misdemeanor dumping. I know he's missed court. I've talked to him about that. We got a good discussion about him making it to court.
I guess just let me know what you guys want.
Okay.
Okay. Marco.
I'm still waiting on the interpreter.
I sent my number to the text, so I'm expecting a call from her, right? Okay.
Great. Never been so.
Judge, I had another matter. Whenever you're ready.
Say it again.
I had Mr. Herrera as well.
Okay.
I think he would just, he either just took the drug test and came back up or.
We sent him on his way already. Judge, we sent him on his way. He's a Monday, Thursday test.
Yeah, they sent him on his way.
Okay, cool. Thank you.
All right. I guess let me know when you're ready, James.
Y todo voz alta.
No. I went to No problem, speak, Judge? That's nice.
Never, man. We haven't tried a case in. Ever.
That's still not so bad.
Yeah, I mean, well, it's, when you have reasonable problem, that's what. You'll find that you'll try more cases because the prosecutors and defense lawyers don't agree, right? So that's why we've been blessed with great prosecutors. That's why we don't try. Which is a good. Got it? Yes. All right. Good morning, Mr. Bustamante.
Good morning.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You now also have an immigration detainer. I will tell you that when you show up to court, good things happen. This doesn't have to happen. But when you continue to miss court, this is what happens. You ever pick up another charge, come to court. It's not a bad thing. You understand? Now you will end up with a conviction on your record. This DWI will go on your record. It will be there for the rest of your life. If you ever get into a car and drive and you have the smell of anything funky, it's probably not going to go well for you. So I would never, even if you've had a sip of alcohol, get into a car and drive. After today, you will now be facing a minimum of 30 days in jail for any new cases that you pick up. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, guilty or not guilty?
Guilty.
I'm gonna find you guilty. I'm gonna sentence you to 30 days in jail. I'll give you credit for the 90 days, the 19 days that you've done. I'm now going to suspend your license for 90 days. Do not drive until you get licensed. Good luck to you, sir.
Thank you, Judge.
Thanks.
And that brings this courtroom session to a powerful close. In the final case, Mr. Herrera faced a DWI charge and accepted an agreement involving jail time with credit for time already served. The judge then made the consequences of that guilty plea extremely clear. This conviction will remain on his record, and another DWI could bring substantially harsher consequences. The judge also emphasized that this was not simply about punishment. It was about preventing future conduct that could endanger other people. Herrera ultimately pleaded guilty, and the judge found him guilty while also explaining that a fee that would normally apply was being waived. The warning was unmistakable. Another mistake involving impaired driving could lead to much more serious penalties. Throughout this session, Judge Fleischer repeatedly stressed compliance, responsibility, and public safety. The message across these cases is clear. Court orders and bond conditions have consequences, and ignoring them can quickly make a difficult legal situation even worse.